Good morning, welcome, and thank you for joining us for our What's Next 2021 Employment Law Forecast webinar. We've still got folks joining, but we had over 400 people registered to attend today's event. So we've got a full virtual house and we've also got a packed agenda. So we're just going to go ahead and get right into it. I'm Jen Ritter-Tomasic, Marketing Coordinator of Events and Proposals at Ward & Smith. Before we begin, I do have a few housekeeping items. We are going to utilize PowerPoint slides throughout this webinar, and we think it will be helpful for you to be able to see both our videos and slides at the same time. To do this, you may need to make one adjustment to your view settings. Find the View Options button at the top or bottom of your screen and click on it to see your options. Then choose side-by-side mode. The slide deck should appear on the left and our videos should appear on the right. You can then slide the separator to the left or right to adjust the size of each view. If you have any issues with video or sound quality during the presentation, please reach out via the Zoom chat feature and I'll try to troubleshoot with you. We have scheduled a short amount of time at the end of the program to answer any questions you may have live. If you have any questions at any time during the webinar, please type them into the Q&A box and we'll do our best to address as many questions as possible during the Q&A discussion. I'd like to take a moment to introduce all of today's presenters. First, we have Ken Gray. Ken leads the firm's labor and employment practice group, and his practice experience encompasses various areas of employment-related litigation. Next, we have Justin Hill. Justin focuses his practice on labor and employment matters. We also have Xavier Lightfoot. Xavier's practice primarily focuses on labor and employment law, serious personal injury and wrongful death, and civil litigation. We also have Emily Massey. Emily focuses her practice on a wide range of labor and employment issues. Also joining us today is former Congressman Mike McIntyre. Mike's professional experience encompasses business, energy, environmental, agribusiness, real estate, and sports and entertainment law. He was also recently selected to receive the North Carolina State Bar's highest honor, the John B. McMillan Distinguished Service Award, which recognizes demonstrated exemplary service to the legal profession. Also joining us today is Will Oden. Will's practice experience encompasses various areas of employment and workplace-related counseling and civil litigation. Up next is Grant Osborne. Grant has more than 30 years of practice experience in a wide range of issues that arise in employment and labor law. We also have Haley Wells. Haley focuses her practice on alcoholic beverage law, labor and employment law, and civil litigation. And our final speaker today is Devin Williams. Devin is one of the firm's managing directors, and her practice focuses on a wide range of labor and employment issues. Now I'll turn the mic over to Ken Gray, and we'll kick things off.
Thank you, everybody, for attending. We know that your time is valuable, and we hope that this will be a worthwhile use of your time. And with that, let's go ahead and get things kicked off. We have the very distinct honor of, in the leadoff position, Mike McIntyre. Congressman McIntyre served as the congressman for a district in southeastern North Carolina from 1997 to 2015. So for 18 years, he was in DC representing the folks in southeastern North Carolina, and he has, as they say, seen how the sausage is made. And so we thought before we get into the specific employment topics that we wanted to focus on for 2021, that it would be good to call on somebody with Congressman McIntyre's experience to just talk about which way the political winds are blowing in DC in 2021. Congressman McIntyre.
Thank you very much. It's good to be with all of you today. Thank you for joining us. And the winds of change indeed in Washington have been changing. Many of us know all of the excitement and the activity and the busyness back and forth going on these past couple of months already as we've gotten into the new year and the new legislative session of Congress and, of course, a new presidential administration. Many folks are at work and are involved in these winds of change. And they're building really a new house of activity. And that new house of activity is built on 4 pillars. And that's what we're going to be focusing on for the next little while. The pandemic, the economic concerns, the climate crisis, and equity. And those are really the four pillars that the new Biden administration has focused on. And most of the activity so far has been focused on the directives or the executive action that the president has taken. And that's going to be a focus of what I share with you, because that is indicative of what winds of change are occurring. And that's where you're going to see Congress responding and agreeing or not agreeing or adjusting that as we look at what has happened even since the day of the inauguration. Some of these you will have heard about in the news. Some of these you may not have heard about, and we're going to highlight many of them under these four pillars. So let's get started with the pandemic, which is, of course, is the most pressing issue on everyone's mind. The first thing President Biden did was issue a directive to provide a unified response to combat COVID-19. And by doing that, he named a coordinator of the COVID-19 response team who would be a counselor directly to the president, so that there would be one person talking to him about every aspect and coordinating with state, local, tribal, and territorial authorities. Secondly, there was an effort to make sure there was an equitable response to the pandemic. And in doing that, that meant making sure there were not disparities. We were noticing early on that according to, depending on the community in a rural, suburban, or urban area, there were disparities. And there was an effort by the administration to immediately make sure, in response to the crisis, that outcomes by race or ethnicity or other factors that may have unfairly affected the distribution now of the vaccine and earlier of healthcare assistance were not being done in the right way. And so there was an effort to collect data to identify shortfalls in the COVID-19 response. Another area is a coordination about something that we hear every day on the news now, and that is about reopening schools. What can be done to make sure that those who are teaching and in education, as well as, of course, the students, are in opportunities that they can learn, but they are also in situations where they can learn safely. And the big emphasis, of course, has been on the elementary and secondary schools with regard to public education. We know there's a separate effort underway with regard to colleges and universities. But the Secretary of Education, in consultation with the Secretary of HHS, are directed to work on this question of school openings across the nation. Making sure there's a sustainable health supply chain. There was also a directive to make sure that supplies are needed and provided for on an ongoing basis to states and to localities, as well as to tribes and to territories. Looking at protecting worker health and safety as we think about what the topic is today. The Secretary of Labor was directed to make sure that there are plans in place that are consistent, not only with state OSHA laws that may be in effect, but make sure those are consistent with the emergency temporary standards that may be issued on the federal level by OSHA. Making sure that also there is direct access to care to COVID-19 patients and that there is equitable use of COVID-19 treatments has been another emphasis. And then also making sure that as we look ahead to the future, that there is a pandemic testing board chaired by the coordinator of COVID-19 to make sure that as we look ahead to other potential public health problems or issues in the future, there is an organized way to be able to deal with and attack those types of public health concerns. There's also been a big emphasis on science in this administration, and there's another directive dealing with making sure that response is data-driven and that the data is collected, studied, and made sure that therefore things are being applied in an equitable fashion. Something you may have seen more familiar to you if you've been on any federal property, federal buildings, federal lands, or if you've interacted with any federal employees. You are required to wear a mask and to maintain social distancing and to follow other public health guidelines. Assistance to the National Guard in the various states and reimbursement to help governors in dealing with the health crisis as they use the National Guard is another directive. And then another one that you probably have seen more about on the news is a directive regarding domestic and international travel, especially in public transportation involving airports, airplanes, and buses, and making sure that incentives are used to encourage widespread mask wearing and physical distancing on public modes of transportation. So all of those fall under that first pillar of dealing with the pandemic. The second pillar is economic relief. And I'm going to say just to the point on that one, that is what is in the news as we speak. There's a great push, as you know, for a $1.9 trillion economic relief package. That is what's being currently debated on Capitol Hill. That is the current wind that is blowing. And that is being done to avoid going through cloture and filibusters and delays and the requirement of a higher number of votes in the Senate, as is typically the case and typically a problem if you're trying to get legislation through, and is built into the process, which was done intentionally, as we know. But there is a procedure called a reconciliation process that can be used for budgeting. And it is rarely used, and it has to be applied only to a budgetary bill, and every part of that bill has to be applicable to the budget. You can't slide in other programs or other remedies for other problems that may be going on. Well, that process, the reconciliation process, can pass by a simple majority in the Senate. And we know the Senate is evenly split right now between Republicans and Democrats, but that Kamala Harris, the vice president, can break the tie. And so there is an opportunity for that 1.9 trillion package to pass, either as proposed or in some form. And there is some debate now about the federal minimum wage at $15 per hour, but there are other parts that are being discussed as well. There may be some massaging or changing some to that package, but essentially that $1.9 trillion package is expected to pass. So more to come as you will get daily about how that develops. The third pillar is to deal with climate. We all know there's been a concern about the heating up of the atmosphere and the climate crisis. It's been discussed quite readily in the news. There's an effort to make sure to protect the public health, that there's a focus on the environment and restoring science to the discussions to tackle the climate crisis. Along that line, the U.S. has gotten more involved in terms of the national and international scene. First of all, one of the interesting things that occurred, and that especially affects our North Carolina coast, is that President Biden revoked a 2017 executive order from President Trump that in turn had revoked an order by President Obama regarding calling on FEMA and other federal agencies to update the federal flood risk management standard. And if you have clients down near the coast, this is going to be a big discussion. I know we're already discussing it with our beach clients. To improve the resilience of communities and federal assets against the impacts of flooding, and by adopting higher flood standards. So that's going to have some ramifications on flood insurance and on residential concerns and on planning for a lot of our local towns in the coastal plain. Another area, of course, is revoking the permit for the Keystone Pipeline, which I'm sure you've heard about in the news. And then there are a host of other directives of President Trump that President Biden has revoked in order to accelerate and attack this issue on climate. He's also called on federal agencies to rescind or to revise certain agency actions related to emissions, fuel economy standards, and efficiency standards. As you probably heard on the news, the U.S. has affirmed the Paris Agreement. That is a change in the winds of change, and also reaffirmed that President Biden will plan to host a Leaders Climate Summit on Earth Day, which is coming up on April 22nd. Some of the other areas that you will hear more about include federal agencies being directed to procure carbon pollution-free electricity, clean zero-emission vehicles, to create, and I'm quoting, good-paying union jobs and to stimulate clean energy industries. Also a requirement that purchases be made in America. And there's a direction to federal agencies to apply and strictly enforce the prevailing wage and benefit guidelines of Davis-Bacon and other acts, and to encourage project labor agreements. And you may well hear more about that in today's webinar as well. The Secretary of Interior has been directed to pause on entering into new oil and natural gas leases on public lands or offshore waters to the extent possible, and to launch a review of all existing leasing, land permitting practices, and those related to fossil fuel development, both on public lands and waters. All of these are going to have ramifications, as you can imagine. And part of the direction to ensure that federal infrastructure investment is climate sensitive is that there will be a new federal siting and permitting process to make sure that those kinds of infrastructure projects are done in an environmentally sustainable manner. Even the Secretary of Agriculture has been encouraged to adopt climate smart agricultural practices that produce verifiable carbon reductions. And there's a working group being established on coal and power plant communities and economic revitalization. So as you can see, there's an attack in every direction on this climate control issue. There's again an effort to restore scientific integrity and evidence-based policymaking, as they call it, with regard to decisions being made with regard to these climate control issues. The fourth pillar is on equity, advancing racial equity and support for underserved communities. We know with some of the events that occurred in our country last year, there's been a great concern about equity. There's an executive order that directs all federal agencies to assess whether or not and to what extent there are programs and policies that perpetuate systematic barriers to benefits for people of color and other underserved groups. And I'm quoting there. Also, yeah, I know you will hear more about this in one of the sessions today. There's a directive to prevent and combat discrimination on the basis of gender identity or sexual orientation, and making those guidelines more consistent with the guidelines we currently have on sex discrimination in general. There was also a memorandum with regard to discriminatory housing practices and policies, and this is something that you will hear more about with regard to equal opportunity for housing, a new emphasis on that to make sure that there are not issues there. And then another very, very notable item in the press is with regard to DACA, the Deferred Action for Childhood Arrivals. We know that the directive issued by the President to the Homeland Security Secretary was to work with the Attorney General to make sure that there is a deferral of the removal of certain undocumented immigrants who were brought to the U.S. as children, who have obeyed the law and who have stayed in school or enlisted in the military, and that they are following the DACA and associated regulations. And also it will permit eligible individuals who pass a background check in their request for temporary relief from removal and to apply for temporary work permits. So there are some requirements clearly that go along with that, but that is a new focus in the Winds of Change. One other area I'll mention in this final fourth pillar, and that is with regard to equity and also equity in government review process. No rules can be issued or proposed until a department or agency head appointed by President Biden has reviewed and approved those rules. So if there's something pending in the Federal Register, for instance, a rule that has been sent to the Federal Register but not yet published must be withdrawn and approved by a department or agency head appointed by President Biden. If a rule has been issued or published in the Federal Register but has not yet become effective, then that department or agency head should consider postponing the rule's effective date until March 21st for the purpose of reviewing any question of fact, law, or policy raised by the rule. So that's something to be aware of with regard to the Federal Register. Also, one other area that President Biden revoked some prior Trump administrative executive orders that had limited collective bargaining, that had cut official time, and that prioritized employee reduction and discipline. So there are going to be some effects here, and I know you're excited about hearing what my fellow attorneys here at the law firm are going to be sharing with you in these areas. And of course, something we've all heard about, there's going to be a pause on the obligation of funds and construction related to the construction of a southern border wall. There are efforts also to end discriminatory bans on entry to the US, and that revoked several of the Trump directives which prevented certain individuals from entering the country, primarily from Muslim and African countries. And once again, there's another directive to make sure and to help American businesses compete in strategic industries by emphasizing made in America products. The final area in our effort on equity that we're seeing in Washington is to strengthen Medicaid and the Affordable Care Act. This directive from the president orders that Medicaid and the Affordable Care Act, under the direction of the Secretary of Health and Human Services, consider establishing a special enrollment period for uninsured and underinsured Americans to seek coverage through the federally facilitated marketplace, considering what's been happening with the ongoing COVID-19 pandemic. In closing, let me say that the president's budget is always the beginning of the long debate about our priorities. And of course, where you put your money is your priority. And that's going to be the debate as the budget will go before subcommittees, full committees this spring. And the plan is before both houses of Congress by the summer, and to get a budget in place and then to get a appropriations bills passed in time for the new federal fiscal year, which begins October 1st. We also know that there are appointments of cabinet secretaries that are occurring. We know that 2 of those cabinet level positions are facing some difficult times now, the director of OMB, the Office of Management and Budget, and also the possibility of there being a different person for HHS secretary because of some senators raising objections. Other than that, the other cabinet appointments look like that they'll go forward, including Michael Regan, who's from North Carolina, of course, with EPA. And it'll be interesting to see how these other cabinet positions are handled that may be contested. The bottom line is the winds of change are blowing. There's a new house being built of activity on those 4 pillars that I've described with regard to the pandemic, the economy, climate, and equity. And you will see those 4 pillars emphasized as we go forward this year. It'll be an opportunity to negotiate, to navigate, and hopefully to appreciate how these changes occur and what we can best do to facilitate these changes in a positive way for our clients, for our communities, and for our countries. God bless you all, and thank you for joining us today. And I, like you, look forward to hearing the rest of our panel now describe how these things are going to be implemented and how they can affect our clients.
Thank you, Congressman McIntyre.
Yes, sir.
I want to go ahead and jump into the first thing that Congressman McIntyre talked about, which was the $1.9 trillion COVID relief package, and look at it just from the employment perspective. And one thing that we all had to deal with, and when I say all, any employer that had less than 500 employees last year from April 1st until December 31st had to deal with the Families First Coronavirus Response Act. And I'll just call that Families First from this point forward. And as you know, Families First expired at the end of the year. However, in the relief package that was passed by Congress and signed by President Trump in December, the law was extended if employers wanted to voluntarily extend it through the March 31st timeframe of this year. An employer did not have to, but if an employer does, then they'll be able to get the corresponding tax credits just like they did last year. Now, what is being proposed by President Biden is that the Families First will be extended and expanded. There's a proposal that it would be extended until September 30th, and it would be mandatory, no longer just voluntary. And then secondly, that the proposal seeks to include certain employers that were not included before, and this would affect everybody on this call because it would potentially affect employers that have more than 500 employees, and also those employers that had less than 50 employees who were able to get exempted out of Families First last year as under the small business exemption. The next part of that proposal is that it would provide over 14 weeks of paid sick leave and family and medical leave. And last year, you may recall, you could get 2 weeks of sick and then an additional 10 weeks of the paid FMLA. And this is talking about 14 weeks, and the maximum leave benefit would be at $1,400 per week. Now, what is not clear about this proposal is whether this requirement would be an extension of the Families First, and thus, if somebody's already taken, say, 10 weeks or say 6 weeks, then they only can take the additional amount that would get them up to 14 weeks, or would the cover workers be entitled to a brand new 14-week period in addition to any paid leave they may have already taken? That part is not yet clearly fleshed out. It will be, and most likely some extension of Families First is going to take place, and it's going to be a matter of exactly what the recipe is, and as that is coming out, we will be doing just like what we did last year in March, just diving into it and determining what the obligations are. And the good news I would say is last year, this was all brought about in a very short period of time. At least now the Department of Labor has some lead time to be planning for this, and they've had a guidebook. So it should not be, hopefully, as confusing as it was last year, but we'll still have to see once the final legislation is agreed upon. The other thing that's proposed about the Families First extension is that certain workers who were excluded or exempted out last year, such as federal workers and certain healthcare workers and first responders, may be included under Families First protection if the law is passed as it's currently written. So obviously there's a lot still to come, and I know some folks had thought they were done with Families First and the paid sick and paid FMLA at the end of last year, but it is likely you're going to have to deal with it again this year in some capacity, and there will be employers most likely that did not have to deal with it because they were either too small or too big that very well may have to. So it'll be interesting to see which way that goes. The other thing I'll mention is something that Congressman McIntyre talked about. As part of this COVID relief package, there is the proposal to increase the federal minimum wage to $15 an hour. And that is something that is definitely on the Biden administration agenda. I think some people were a little surprised that it was included in the COVID relief package, but it is definitely something that's on the table right now. And one potential hiccup there is that Senator Joe Manchin, the Democrat from West Virginia, has indicated that he is not in favor of a $15 minimum wage at this time, but he has come back and said he would be inclined to agree to something in the $11 an hour range. And then I will also say that Republican Senators Mitt Romney and Tom Cotton have thrown out a proposal for a $10 an hour minimum wage. So at some point, it is extremely likely if not through this COVID relief package, because it's possible that the Senate will drop it out of the package. But at some point in the next 2 years, the minimum wage is going to go up. It's just a matter of how much. And a lot of people had talked about a step up over a period of time, minimum wage, perhaps going up a couple dollars, a year. But in this COVID relief package, the Biden administration is wanting to get to $15 immediately. So there's still some discussion that's going to take place very soon about this minimum wage issue, and we'll see whether it stays in the COVID relief package or if it's going to get kicked down the road a little bit and be dealt with on its own merits. The next thing I would mention under the COVID relief proposal is that there will be another unemployment insurance boost. Last year, when the government did its first relief package, you'll recall that unemployment was supplemented by $600 in federal money, in addition to what the state was putting out there. In the most recent relief package that did get passed in December, the number went down to $300 extra per week. And in this new proposal, they're proposing that it goes up to $400. So it's definitely something that's that part's going to happen. It's very similar to what happened back a decade ago plus, when we had the economic meltdown, and there were folks that ended up being on unemployment for up to 2 years as Congress kept extending unemployment benefits. And in certain markets where you have a tight labor force, it can make filling every seat in the office somewhat difficult. But nonetheless, there are a lot of people that are out of work and need a benefit. And so I think that the government is looking at some compromised position there. But right now, the proposal is at increasing the supplement by $400 per week. Now, the next topic is that, and Congressman McIntyre briefly mentioned it, since we're in the midst of the COVID-19 pandemic, obviously workplace safety issues are paramount on everybody's mind. And the thing that we know for sure is that the Biden administration has ordered OSHA to come out with new regulations and rules, and Justin Hill's going to speak about those later today. And so I'm going to just move on, but I will say that the Biden administration is definitely expecting OSHA to increase its enforcement efforts. And what we know beyond just dealing with COVID-19 is that not only will OSHA beef up its enforcement program, but it's going to continue certain regulatory changes that the Obama administration started and the Trump administration paused or even reversed. So that's coming. Now, if you look at the enforcement side, in other words, the people that come out and investigate OSHA complaints or do random investigations of certain industries, right now, that enforcement staff is at essentially the lowest number of OSHA inspectors that it has been virtually in the history of OSHA. It is essentially at a 49-year low, and it is, they are struggling, but nonetheless, in 2020, they did hand out over $3.9 million in OSHA-related or COVID-related OSHA citations. So that is something that's going to continue to be an issue. I've handled one of those in the last week. I think since April of last year, we've handled in excess of 20 OSHA complaints that are purely COVID related. And so that is definitely something that you need to be on the lookout for and make sure you have policies in place. And so what I would conclude about the OSHA component is that employers should be preparing now for more inspections in the near future because they do have a directive to get out there and be tougher on employers to make sure that employees have safe working conditions. Now, Will Oden in a moment is going to talk about the next topic, so I just wanted to mention it as something that you can expect to see. I'm sure most of you are aware that the Department of Labor last year was dealing with a new independent contractor rule, and that has essentially been finalized as of January 7, and Will's going to tell you perhaps what you can expect in regard to that final rule. I'm going to also mention the National Labor Relations Board because there's been an interesting development there. And some folks say, well, wait a second, I don't have a union in my workplace. Why do I care about the National Labor Relations Board? Well, any private employer that's part of this call today, you're subject to certain portions of the National Labor Relations Act, regardless of whether or not you have a union on site. And so it was quite interesting what the president did here. And this was the first time this has ever happened. I mean, within hours of being sworn in on January 20th, President Biden took an unprecedented step of firing the National Labor Relations Board's chief prosecutor, Peter Robb. Now, this was the first time that a sitting general counsel for the NLRB had been fired before the end of his term. I mean, the only thing that was comparable, you could go back to President Truman, who asked his general counsel in 1950 to resign, and that person complied. President Biden asked General Counsel Robb to resign. He refused, and so President Biden terminated him. And immediately thereafter, the president then terminated the deputy general counsel, Alice Stock. And so that sent a very clear message that the Biden administration is looking to be much more sympathetic to union interest and to employee protection issues. So it's definitely something that you need to be aware of, and where that would affect, there's a lot of effect with folks that deal with unions, but for the folks that do not deal with unions, certainly this could result in tougher requirements for employers who are potentially disciplining or trying to discipline employees for social media posts. And we have to be very careful if any social media post touches on terms and conditions of employment. So anyway, that's one thing that we're definitely looking at really closely with the NLRB. One area that we think will actually be less enforcement potentially, and that's on the immigration front. I think a number of employers over the last 4 years have been very concerned about having people that were undocumented in their workforce, and that may not be quite as big of a focus with this particular administration. I will also mention, just as an aside, Washington, D.C., the city itself is looking at is passing legislation banning non-compete agreements, and so there is actually a movement afoot to try to get a federal ban on non-compete agreements with certain exceptions that would apply when they're truly needed. Now, I do not anticipate that is going to be something that we see come to fruition in this next term. I think that an administration can only get so many things accomplished, and you only have so much political capital. And I can say that 12 years ago, when we were having a very similar presentation and we were talking about what to expect with the Obama administration, we did expect a lot of union activity because Senator Obama had been very vocal about support for unions. And so all the experts thought that unions were going to be, that were just going to explode under President Obama. And what happened was that President Obama put all his political capital into the Affordable Care Act, Obamacare, and basically that was his signature. But that pretty much, it carried the day when it came to what the things that the Obama administration was able to get through after that. And so typically an administration can only get so much through, and that's not something that we feel like will happen, but it's a possibility. And there are ways to counter, or there are alternatives to non-competes that we have prepared for clients. And so that's certainly something that you can give consideration to. For example, in most of the medical practices that we represent, we're going to cost share arrangements, which basically requires a reimbursement of certain expenses if somebody leaves the practice and then wants to go to work in the restricted territory. It doesn't stop them from competing or going to work, but they have to make a payment. And so there are alternatives, but it's certainly something that you have to take into consideration if, courts don't like non-competes. And I think more and more we're going to see folks trying to look for other alternatives. We expect that the administration will also focus on a number of Fair Labor Standards Act matters, wage and hour issues. There could be an attempt to increase the white collar exemptions from overtime provisions. You'll recall back 5.5 years ago or so, the Obama administration had proposed increasing the minimum amount as an exempt employee would have to make to still be exempt, all the way up to $48,000 from 23,000 and change. And right at the end of the administration, there was a court case that pretty much nipped that in the bud. And then once the Trump administration took over, they pretty much abandoned that 48,000 figure. And then later during the Trump administration came back with a $36,000 minimum number. And that's what we're currently under. And there could be an effort to potentially try to increase that. It will definitely be telegraphed well in advance, and we'll be able to talk about that with folks, but that is a possibility. The other thing that is a possibility is that one thing that neither the Obama administration's proposals, when they were trying to increase the minimum number to 48,000, nor the Trump administration dealt with, they didn't try to deal with the duties test to determine does somebody actually meet the executive exemption or the administrative exemption or the professional exemption. They left the duties test as they have been for many years. And there is the thought process that perhaps if they don't increase the minimum amount, the salary that somebody must make to be exempt, they may make the duties more stringent so that you have less people qualifying as somebody that's exempt. Certainly anybody that deals with federal contracts, we expect a lot more activity out of the Office of Federal Contract Compliance, OFCCP. They deal with the discrimination issues and Equal Pay Act issues with companies that deal with the federal government. And certainly we expect the EEOC to continue to be aggressive. Now, the one thing about the EEOC, and I know we have some representatives that have logged in from the commission on this call today, and appreciate you guys logging in. I think the EEOC has remained fairly consistent from one administration to the next. We do expect to see much more aggressive enforcement actions. We expect to see more litigation involving allegations of systemic discrimination, workplace harassment, and equal pay issues. And I think it's going to be very clear, and some of the trainings that we've been doing, we've already been talking about this, and this is a topic that Xavier Lightfoot's going to speak about in a moment. We're pretty certain the EEOC is going to emphasize concerns about gender identity and sexual orientation matters. And because that's those are topics that the EEOC has long taken a very strong position on, and it turned out they were correct in the position that they had taken, according to the U.S. Supreme Court. And so we would have expected even more aggressive enforcement on those issues, but COVID came along in 2020, and it really sucked up all the oxygen in the room, and it put everybody in a tailspin. And so I think that we're going to see a lot more sexual orientations and particularly gender identity issues. Xavier will talk about that, and you'll probably also hear some suggestions about training from Emily Massey in regard to that as well. And with that being said, I will conclude with the EEOC recently, earlier this year, issued revised enforcement guidance on religious discrimination. And basically it's saying that you should provide accommodations for folks in the workplace if you can. And some of those accommodations for religious issue, asking for a religious accommodation would include flexible scheduling, voluntary substitutes or swaps of shifts and assignments, lateral transfers, or job change or changes in job assignment, and modifying workplace practices, policies, and procedures. Other practices policies, procedures may include things that deal with dress and grooming standards, rules regarding the use of employer facilities, tests and other selection procedures, and employer identification procedures. So, you know, there is definitely going to be a focus on individuals who ask for religious accommodation. And because the big issue that we're seeing now too, really, one is if you deny a request for a religious accommodation, but no other adverse action is taken, does that give rise to a claim? And the EEOC says it does. There is a court that has said it doesn't. So this may be an issue that the EEOC ends up litigating up to the Supreme Court. And the other potential issue that we see regarding religious accommodations could be when it's in contra to LGBTQ issues. And so there could be a battle between two different sets of rights. And that's something that I think that the EEOC and the courts will also expand upon. And with that said, I'm going to turn it over to Haley Wells, who's going to talk about something that I think is the most pressing issue right now, COVID-19 vaccination issues. I think it's pressing because we're getting calls on a daily basis about it. I was actually interviewed, and there was a TV segment that aired last night on the local ABC affiliate in New Bern on this very topic. So it is very much front and center. So with that being said, I'll turn it over to Haley.
Thank you, Ken, and thank you for that comprehensive overview of the new administration's priorities and what sort of changes we can expect to see out of Washington in the next 4 years. As Ken said, this is probably the question that we are getting the most right now and have been receiving pretty frequently over the last 90 days from employers. And it has to do with the concept of a COVID-19 vaccination mandate and related policies. It makes sense, if you think about it, that employers are considering these types of mandates or policies because everyone is eager to get back to normal, to get as many employees as possible back in the workplace. And one path that many employers are considering to do that is the idea of a vaccination mandate. So the initial question of, can an employer mandate that employees receive the COVID-19 vaccine as a condition for working on site? The answer to that question is pretty simple, and the answer is yes. The tougher question arises when an employee refuses or indicates that they're unable to receive the vaccine. It's at that point that the employer must ask, why is the employee refusing the vaccine? Is it because of a disability or a serious health condition? Is it because of some sincerely held religious belief? Is it possible that the employee is pregnant? Or is it simply a personal preference of the employee that they're not comfortable receiving the vaccination? Each of these requires a little bit different analysis for the employer to engage in. And we're going to walk through some of that analysis so that you can evaluate whether or not you're comfortable with your organization implementing a vaccination mandate. Is it consistent with your company culture? What will the impact be on employee morale? Those are all things that go into the decision of whether or not to implement such a mandate. So the first category of employees are employees who are going to refuse the vaccination because of a serious health condition or because of a disability. In that instance, the employer must engage in the ADA's interactive process. Now, the ADA does allow an employer to have a qualification standard that includes a requirement that an individual not pose a direct threat to the health or safety of individuals in the workplace. So it is conceivable under the ADA that a vaccination mandate could be a qualification standard. However, if a safety-based qualification standard, such as a vaccination requirement, screens out or tends to screen out an individual with a disability, then the employer must show that an unvaccinated employee would pose a direct threat due to a significant risk of substantial harm to the health or safety of the individual or others that cannot be eliminated or reduced by reasonable accommodation. Now, that's a bit of a mouthful, but that's what the law requires. And we're going to break that down a little bit so that you can understand how this is applied in practice. So the first thing that you must consider when implementing a vaccination mandate, and then you have the situation where an employee comes to you and says, I'm not able to receive the vaccine because of a disability, is whether or not the employee will pose a direct threat in their unvaccinated state. In order to consider that or to reach that decision, an employer must consider 4 factors. The first is the duration of the risk. The second is the nature and severity of the potential harm posed by the employee. The third is the likelihood that the potential harm will occur. And the fourth is the imminence of the potential harm. A conclusion that there is a direct threat would necessarily include a determination by the employer that an unvaccinated individual will expose others to the virus at the work site. In reaching that determination, an employer must also consider the physical configuration of the workplace and assess whether or not there is adequate separation between employees or employees and customers, whether there's sufficient ventilation, and how often and how frequently employees or employees and customers are physically interacting with each other or occupying the same space. While there may be some frontline businesses that employ essential workers that may be able to justify that the vaccine is a legitimate qualification standard, businesses that come to mind that would meet that, that definition would be hospitals, physicians' offices, dental offices, childcare providers. Other organizations that have individuals working in a more typical office environment or in individual offices may not be able to demonstrate that a vaccination mandate is a legitimate qualification standard. If an employer determines that an individual who cannot be vaccinated due to a disability does pose a direct threat at the work site, the employer cannot simply exclude that employee from the workplace, and they certainly should not immediately jump to a termination of that employee. Instead, you must engage in the interactive process and determine what sort of reasonable accommodation may be available that would eliminate or reduce that direct threat. Things that come to mind include separating the unvaccinated employee into an office space where they're not coming into contact with other employees, or if the workplace is one where the employees' schedules can be staggered, having the unvaccinated employee work at off hours. If, however, the employee determines that there is a direct threat and it cannot be reduced to an acceptable level, the employer could at that point exclude the employee from physically entering the workplace. There again, we don't jump immediately to, aha, we can terminate this employee. You must further engage in the interactive process and determine, are there reasonable accommodations that would allow the employee to continue to work while being physically excluded from the workplace. The one that immediately comes to mind in our current environment is teleworking, particularly given that so many employees have been teleworking for an extended period of time over the last year. If that is a reasonable accommodation and one that does not pose an undue hardship, then it is one that the employer must consider in this circumstance. Additionally, Make sure that your managers and supervisors know how and when to recognize that an employee is requesting a reasonable accommodation, and that they know who within your organization those requests should be referred to. We recognize that there may be situations where an accommodation is not reasonable or possible because it is simply a requirement of your workplace that employees be physically present at the job site. When making that sort of determination or decision, documentation is key, because if the decision is later challenged, you need to be able to point to the particular job duties of the position and to demonstrate the analysis that you engaged in determining that the employee posed a direct threat and that there was not a reasonable accommodation that would have allowed you to minimize or to reduce that threat. Also, remind your managers and supervisors that it is unlawful to disclose that an employee is receiving a reasonable accommodation or to retaliate against an employee for requesting a reasonable accommodation. So that's our first category of employees, those who are unable to comply with a vaccination mandate because of a disability. The second is going to be the category of employees who are unable or unwilling to comply with a vaccine mandate because of a sincerely held religious belief. Once an employer is on notice that an employee's sincerely held religious belief, practice, or observance prevents the employee from receiving the vaccine, the employee must provide a reasonable accommodation for that religious belief. The EEOC has issued guidance on this topic, and the guidance is broad and expansive, and it explains that because the definition of religion is broad, and it protects beliefs, practices, and observances which the employer may be unfamiliar with, the employer should ordinarily assume that an employee's request for a religious accommodation is based on a sincerely held religious belief. There is a small exception, and I would submit it is a very narrow exception and one that you should tread lightly if you're going to consider it. And that is, employers may request additional information from an employee if the employer has an objective basis to question whether a religious belief is sincerely held by the employee. However, in that case, it's going to be important to involve legal counsel and, once again, to make sure that you have documented that decision-making process, because if that decision is ever challenged by the employee or looked into by the EEOC, you're going to want to have a very strong paper trail as to why you denied the request for reasonable accommodation, because you, the employer, contend that the employee's sincerely held religious belief was not in fact sincere. If an employer cannot exempt or provide a reasonable accommodation to an employee from its mandatory COVID vaccine mandate, then the employer can, in that instance, consider excluding the employee from the workplace. However, as I mentioned earlier when we were talking about the ADA, simply because an employee can be physically excluded from the workplace because of a direct threat does not mean that the employer is free to terminate that employee. The employer must engage in the interactive process to determine what sort of reasonable accommodations may be available to accommodate employees both under the ADA as well as under Title VII for sincerely held religious beliefs. The same analysis that applies to considering a religious objection to a COVID vaccination mandate also applies to employees who are refusing a vaccine because they are pregnant and concerned about the vaccination's impact on fetal development. Please be aware that the risk of a vaccine mandate places you as the employer in the position of inquiring of your employees why they are refusing to comply with it, and possibly learning about information that places your employees in a protected class that you may otherwise be unaware of, and that may not be information that you necessarily want to know or to gather about your employees. Many employers have found that a better approach is making a strong recommendation or encouraging their workforce to get the COVID vaccine. Better yet, other employers are considering incentives, which are permitted both in the form of time off or financial incentives to encourage employees to go get the vaccine. Recent polls have shown that 27 to 40% of Americans may decline to obtain the COVID vaccine. In considering whether or not you want to implement a COVID vaccine mandate, consider what that would do to your workforce if that percentage of your employees objected or refused to comply with the mandate. Now that you understand the legal analysis that you must engage in, you have to ask the tougher question that organizations face, and that is, should our organization mandate the vaccine? The answer to this question will be driven by a few factors, including your company culture, the impact on employee morale, and your willingness as an organization and the resources of your organization to micromanage the process to ensure compliance, as well as to engage in the interactive process that will necessarily be required when your employees refuse the vaccine. With that, I'm now going to turn things over to my law partner, Xavier Lightfoot, who's going to talk to us about LGBTQ issues.
Thank you, Haley. Hello, everyone. Thank you for all being with us again today. We know that these are some important issues for you all in your organizations, and we want to provide you with some information that's going to help you out moving forward. So today, I'm going to talk to you briefly on some important developments as it relates to LGBTQ plus issues in the workplace. My goal is to do three things. First, I am going to provide a brief overview on how the law has developed recently in this environment. Second, I'm going to talk briefly on how the current administration under President Biden views these issues. And finally, I will wrap up by leaving you with some practical implications that your organizations will want to bear in mind as we move forward under the new administration. So getting us started here, discussing the protections and limitations as it relates to LGBTQ plus rights. Last year, in the summer, we had a landmark decision come down from the Supreme Court of the United States, and it addressed LGBTQ plus protections in the workplace. That case was titled Bostick versus Clayton County, Georgia. And I'll refer to it throughout as Bostick for short. So Bostick was a consolidated decision that settled a split that we had in the federal appellate courts and resolved three separate cases where an individual was terminated after revealing that he or she was homosexual or transgender. So the Bostick case focused on Title VII of the 1964 Civil Rights Act and Title VII's prohibition on sex-based discrimination and whether or not sexual orientation and gender identity was included under the phrase because of sex. The court ruled that Title VII does cover individuals who are discriminated against because of their sexual orientation or gender identity. And it's an important decision and landmark ruling because prior to Bostick, we had about 25 states, including North Carolina and several territories, who did not have laws that expressly prohibit employment discrimination based on sexual orientation and gender identity. So as a result of the court's decision in Bostick, all individuals now in every state and territory now are afforded these federal protections under Title VII. And so individuals who feel like they may have been discriminated against in their workplaces, they can now file a charge with the EEOC, or they can subsequently pursue a private action in the federal courts based on these type of actions. So while Bostick gave us a clear rule on Title VII's applicability to sexual orientation and gender identity, the court's decision did not address other related issues, such as religious exemptions. In fact, the very next month following the Bostock decision, the Supreme Court actually decided a case that expanded the scope of what's called the ministerial exception. And in that exception, it precludes Title VII's application for employment discrimination to questions involving the employment relationship between a religious institution and its ministers. That case was titled Our Lady of Guadalupe School versus Morrissey Baru. And so basically the court held that two teachers who were barred, two teachers were barred from suing their employers for age and disability discrimination because of the ministerial exception and the fact that that exception applies to employees who are performing vital religious duties, regardless of the employee's official titles or religious training. So that case is important because it kind of gives us an idea as to where the court is headed. And it looks like the court appears more willing to apply that exception to a wider range of employers and employees beyond your traditional houses of worship or clear religious organizations. The law has developed a good bit in this environment, and I will talk to you in just a moment about those practical considerations for your workplaces and your organizations. But before we do that, I want to discuss briefly, how the current administration is going to view these type of issues. So within hours of President Biden being inaugurated on January 20th, the president signed an executive order titled Preventing and Combating Discrimination on the Basis of Gender Identity and Sexual Orientation. That particular executive order establishes the new administration's policy to prohibit discrimination on the basis of gender identity and sexual orientation, and it directs all federal agencies to take affirmative steps to secure rights for those individuals. Specifically in the order, the administration indicated that it intends to apply the Supreme Court's holding in the Bostock decision to any other federal law that prohibits sex discrimination. So we're talking about the Fair Housing Act. We're talking about Section 412 of the Immigration and Nationality Act, and also the Affordable Care Act. So now the heads of each federal agency, they have a directive to reevaluate their agency's policies and regulations in light of the Bostock decision and make changes consistent with the president's executive order within 100 days. So we will see a lot coming down the pipeline here pretty soon. The thing that we also want to keep in mind is that, while we still have, or while we have the Bostock decision, while we now have President Biden's executive order on how he wants to move forward with his administration in addressing these issues, there's also legislation that could come down the pipeline as well. And that's the Equality Act. The Equality Act has received strong support by the president. He has actually stated that he's committed to enacting that piece of legislation during his first 100 days. And that's going to be a top legislative priority. Basically, the Equality Act is going to amend existing civil rights laws, including the Civil Rights Act of 1964, the Fair Housing Act, the Equal Credit Opportunity Act, and several other laws regarding employment with the federal government to expressly include sexual orientation and gender identity as protected characteristics. So that legislation is effectively going to provide consistent and express non-discrimination protections for LGBTQ plus individuals across key areas. It's going to include employment, housing, credit, education, public spaces and services, and also federally funded programs. So we're likely to see a lot more in the coming months in this particular environment from federal legislation and regulations. And we will certainly try to keep you all abreast to those developments as they come down. The last thing that I want to talk to you about here during my time is just, some practical considerations that you all as organizations and employers, you want to keep in mind to move forward. If you've attended some of the other employment webinars that we had last summer and in the fall following the Bostic decision, then you know that we've been advising clients to take a closer look at their handbooks and review your employment policies as it relates to those anti-discrimination policies, just to ensure that your handbooks and your policies are compliant to reflect the legal developments provided by Bostic. Due to the social justice movement that we had this summer, we have seen many clients take a more aggressive approach in addressing diversity, equity, and inclusion issues, but also including LGBTQ plus issues. And our employment team has been busy in this area, helping our clients to revise their policies, review training content, and conduct training on these policies. We believe all organizations should conduct some type of training on these issues. As my law partner, Ken Gray, stated earlier, we expect the EEOC will take a more aggressive approach on these type of issues, especially given how the administration has made this a priority. So, and the EEOC has also published guidance in this particular area. They published a guidance document following the Bostic decision at the end of June that basically lays out the protections for LGBTQ plus individuals and provides the steps that those individuals should take if they feel like their employer has violated their rights under Title VII. As I stated earlier, there are some controversial matters that were not decided by Bostic, such as sex-separated bathrooms, locker rooms, things like that. And so we are going to have to, we're going to see some court challenges. We're going to see some legal challenges. The court is going to take steps to figure out, how this environment is going to be developed. But what we advise all of our clients is that you don't want to be the test case. You don't want to make your organization the test case for how this area is going to be developed. So we think, the best thing to do is to take a more conservative approach to adopt pro-LGBTQ plus policies or neutral policies and just consider conducting that type of training because you want to make sure your employers know the importance of these type of issues. And you don't want anyone to do something that is going to put you out there in the spotlight or make you a headline if it's something that you can prevent on the front end. So, we're happy to help you in this area. That's going to conclude my portion for these type of issues. Now I'm going to turn it over to my law partner and my good friend, Grant Osborne.
Good morning. So my subject today, I admit, is rather ambitious. Thank you, Xavier, by the way. Sorry about that. My subject is rather ambitious. As you can see, it's the subject of rejection of applicants and discipline or discharge of employees based on what they do outside of work. Several of my partners are to speak after me, so I'll try to be careful about the time. As you all know, the employment relationship, given what you've heard this morning especially, is very complicated. The law has a lot to say about the employment relationship, as we all know. As you can see from the slide, employment laws, both federal and state, have a lot to say to employers about how they can recruit applicants, what questions they might ask of recruits, for example, how employers may and may not lawfully pay their employees, and what information employers may or may not properly consider when recruiting employees, hiring employees, and deciding whether to discipline or keep employees. It's a very thorny subject. I cannot do it great justice in about 10 minutes, but I'll give it a try. So I raise this subject because in these frothy times when employees' behavior can become instant news, with the miracle of the iPhone, everything that people do and say can become public very quickly, as we all know. The illegal, controversial, and even reckless behavior and statements of applicants and employees can become instant news, and therefore employers these days are wondering, I think even more than before, certainly before the pandemic, whether they may lawfully consider such behavior in deciding whom to hire, whom to discipline, and whom to fire. The short answer, you'll be amazed from a lawyer, there is a short answer. The short answer in North Carolina, because we have to look at both federal and state law, is yes, as a rule, employers may consider the out of workplace conduct of applicants and employees. I say that because there is no federal or state law that categorically prohibits employers from considering the conduct of applicants and employees in their private or personal lives. Having said that, though, that's really just the beginning, because there are a lot of exceptions that I'll get to in just a moment. But just to give us some context, what kinds of behavior or statements might employers want to consider when evaluating whom to hire and evaluating whom to keep, quite frankly? I'll just list a few examples in the time we have. Number one, conviction of a crime. May you consider that? Many employers would want to consider that. What about being charged with a crime or being arrested on suspicion, mere suspicion of having committed a crime? Arrest is a special category all itself under Title VII because of the implications under Title VII that I'll get to in a moment. What about threats of violence? Again, I'm talking about conduct and statements outside of the workplace, not at work. Threats of violence. What about publication of incendiary or offensive statements in social media or otherwise? These days, we might add participation in a public insurrection. That would have seemed silly a year ago, perhaps not so much anymore. And I might add, finally, what about a cavalier approach to the risk of contagion? What if you have applicants or employees whom you think are not being careful as far as the risk of contracting disease is concerned? As Haley was mentioning, employees can bring a direct threat into the workplace depending upon how they handle the risk of contagion. So those are just some examples of the kinds of behavior and statements that employers may want to consider. That is the rule, but as to private employers, and that's all we have time to talk about today, not governmental employers, but as to private employers, there are many exceptions of which employers have got to be aware. As James Thurber once said, there is no exception to the rule that every rule has an exception. There are many exceptions, and if you don't know what they are, you can inadvertently land in hot water. And so in the brief time that I have left, without hopefully getting into the time of my colleagues, we'll just hit a few of those exceptions now. And let me add, by the way, this is not a complete list. It's an exhaustive list and maybe kind of tedious, but it's not complete. There are some others, but the most conspicuous exceptions are those that we'll go over right now. As you can see on the slide, the most prominent one is Title VII of the Civil Rights Act. That's the federal law, as many of you know, I'm sure, that prohibits discrimination based on race, color, religion, sex, and national origin. Title VII comes into play because it does prohibit, among other prohibitions, discrimination based on religious practices. Certainly that's conduct in which people engage outside of work. So Title VII has been construed for a long time to prohibit discrimination based upon religious practices. Title VII, according to the EEOC, also takes a dim view of consideration of mere arrests. The idea is that being arrested for something, of course, does not mean that somebody did anything wrong. It simply means a person's arrested. And to sum it up, there is this notion that under Title VII, what's called disparate impacts, meaning that a practice or policy has a disparate or differing impact on some employees as opposed to others. For example, with respect to persons or employees' race and national origin. I apologize for that. That will pass in a moment, I hope. Number two is the ADA. This is a little counterintuitive. Many people know that the ADA prohibits discrimination based on disability, but it also prohibits discrimination based on mere association with a person with a disability. In other words, an applicant or an employee may contend that his or her association with someone with a disability was used or considered as a basis on which to hire or discharge. And the ADA has a lot to say about that. Again, I know I'm giving you kind of a drive-by given the limitations of time, but I hope this is helpful nonetheless. Number three, the Federal Rehabilitation Act. That applies to employers with federal contracts or subcontracts that exceed $10,000. And it's much like the ADA in that it does provide that some individuals have the right to bring a claim, meaning to file a lawsuit, because of an association with a disabled person. Next, this one takes almost too long to say, the Uniformed Services Employment and Reemployment Rights Act. That law, called USERRA, that's the acronym, prohibits discrimination based on past, current, or even prospective military service. We might wonder why in the world would an employer these days want to discriminate against anyone based on past, current, or prospective military service. But nonetheless, it's conceivable, and this federal law makes such discrimination unlawful. So when considering an applicant or an employee who does have past, present, or past, current, or prospective military service, you need to be aware that this law is out there. Next, I guess we're up to number 5, the Immigration and Reform and Control Act, called IRCA to lawyers, IRCA. Like Title VII in a way, it prohibits discrimination, intentional discrimination in hiring and termination based upon an applicant's or employee's accent or simply appearing foreign. Again, it's disappointing to think that anybody would wish to engage in such discrimination, but it is conceivable. And this law, in addition to Title VII, prohibits discrimination against an applicant or an employee's merely having an accent or engaging in conduct that seems, quote, foreign. And that's the term that's used. So I'll present that to you. Number 6, and you heard my colleague Ken Gray touch on this a while ago, the National Labor Relations Act. As far as private employers are concerned, they are not subject to constitutional limitations pertaining to freedom of speech, freedom of religion, the right of assembly. But there is this federal law that's been around for a long time and amended many times that does apply to essentially all private employers, regardless of size. And as Ken said, regardless of whether a union is on the scene. This federal law protects the right of employees to engage in what we generally call protected concerted activity, meaning the right to engage in collective behavior for the purpose of discussing and perhaps trying to improve working conditions. That applies to all private employers. And so if applicants, or rather if employees engage in this behavior outside of work, employers have to be careful to avoid the appearance of having interfered with these rights that are generally called Section 7 rights because they arise under Section 7 of this particular statute. So just be aware that your employees have a right to confer with one another about wages and terms and conditions of employment under this statute. And that employers that interfere with these rights or try to coerce employees in some way can be on the business end of what's called an unfair labor practice charge, which is brought before the National Labor Relations Board that you heard Ken, I think, mention earlier today. So I have 2 more on this list as far as federal law is concerned. And that's all we've been discussing so far. It's just the federal law. I'll get to North Carolina law in a moment. This next one, I'll confess, I had to learn a bit about in preparing for this. It's called the Consumer Credit Protection Act. The short takeaway, because it's pretty involved, is that this law prohibits employers from firing an employee because the employee's earnings have been subject to a garnishment. Perhaps many of you would not think that's even, you would not be inclined to do that. Who would want to fire somebody just because his or her wages were garnished? But there is this federal law, again called the CCPA, that makes it unlawful to discharge an employee because his or her earnings have been garnished. And in fact, even if for employers who have progressive discipline policies, which are pretty common, if an employee gets a warning based on a garnishment, that can violate the statute as well. There is one wrinkle on this that I think should get your attention. It certainly got mine. Unlike these other statutes that we've talked about that expose employers to civil liability, meaning they can be sued and have to pay damages, employers that violate this Consumer Credit Protection Act can be fined up to $1,000 and be imprisoned for up to a year. So there is a criminal component to this. So if you're dealing with an employee whose wages have been garnished, just be aware that this law is out there and one needs to be careful of violating it. There is one more I'll add to the list for those who are taking notes and wish for extra credit. Under the U.S. Bankruptcy Code, there is a section of the Bankruptcy Code that makes it unlawful to discriminate against an employee because the employee has been a debtor or in bankruptcy or has merely been associated with a debtor in bankruptcy. I think this is a somewhat obscure rule. So just be aware that if you have bankruptcy in the picture, be careful of that. I see I don't have a lot of time left, so what I'll do now is simply mention this long list. We can certainly provide it to you. As you can see, there are many state statutes that implicate the conduct and statements of employees off the job. I will not try to read all of them to you, but be aware that there are many laws in North Carolina that do, in effect, prohibit employers from considering certain behaviors of applicants and employees off the job. Number two is probably just worth a mention in case you're not aware of it. As you can see, it's called discrimination against persons for lawful use of lawful products during non-working hours. So we actually have a statute in North Carolina that protects the right of employees in many cases to engage in lawful use of lawful products such as alcohol, tobacco, now CBD, on their own time. So employers need to be careful about what they consider. Given the hour, it's about 11:26. We have other people to follow me. So I'll just close with this observation that if you're going to consider the conduct or statements of applicants or employees outside the workplace, then we recommend that you be very careful to avoid the appearance that you considered conduct or statements that may be protected by law. I'll end with a quotation just because I think it's helpful. Peter Drucker, whom I think we may know of, once said, and I'll paraphrase here, that one cannot hire just a hand. The whole person always comes with it. So you want to be careful. You have a right to consider the behavior of applicants and employees outside of work, but be careful when doing so. And I guess my time is now up. So I'll now lateral the ball to my partner, Will Oden, who will talk with you about the difference between independent contractors and employees.
Thanks, Grant. I appreciate that. And actually, I think we're going to turn it over to Emily real briefly before I take over.
It's okay, Grant. I won't hold that against you.
My apologies. Sorry about that, Emily.
No problem. I will be brief because I just want to share a few quick hitters with everyone. I know a new year means a lot of times employers reissue their employee handbooks. And I just want to remind you that there's never a bad time to reissue your employee handbook. You can do it at any time. And importantly, there's never a bad time to revisit your policies and to issue new policies as circumstances change. A lot of you likely have experienced that over the past year. The key is to ensure that your policies are compliant with the law, reflect your practices, and are communicated to employees. Here are a few policies that you should ensure are updated right now. First, anti-discrimination. We've talked about that a lot today. As Xavier discussed, the Bossick case means that sexual orientation and gender identity must be included in these policies, even though they may have already been in some of yours due to the EEOC's enforcement. Also, take a look at your reporting process for complaining about discrimination or harassment. Oftentimes we see a complex reporting system, and we generally recommend having multiple avenues to complain and not having a complex system, for instance, reporting to a certain person because positions change, people move in and out of positions. We want this to be a very easy process, an open door policy for employees to complain. The second policy is teleworking or flexible work. Whether or not your business allows the possibility to telework, this past year has shown that we need to be prepared for that circumstance. What happens if you need to move your workforce remotely? So your policy can simply say, this policy only applies under certain circumstances, or it could be that you allow employees to telework upon getting permission. Just make sure it's very clear. Either way, make sure that such policies set clear expectations for what employees should do when they're working from home. For example, how to keep their time, how often they should be checking in with their supervisor, the type of Zoom etiquette, and so forth. The next policies to take a look at are your leave policies. An issue that we saw a lot of employers face when the COVID-19 pandemic hit was related to leave. Okay, all my employees now want to take PTO. Can they do it? Well, what does your policy say? And so you need to ensure that your vacation and PTO policies, if you have them, are clear on when an employee can use their leave, how it is accrued, how it's carried over from year to year, et cetera. And just a reminder that in North Carolina, if you do not allow employees to carry over their PTO or vacation or to have it paid out upon termination, you must have a clear forfeiture clause in your policy that is also communicated to employees. Otherwise, those accrued unused hours are considered wages and have to be paid, even if it's a layoff, for example. And this also, just to briefly remind you to update your unpaid leave policies. What if an employee wants to take a leave of absence? And also to revisit your training, which I'll talk about next, on training your managers and supervisors how to handle requests for unpaid leave of absences, especially when disability is involved or medical conditions. Finally, and Ken talked about this, but as it relates to paid leave, many of you may have been subject to the Families First or FFCRA, and so you may have policies related to that. Remember that you're no longer required to provide that leave, but if you are choosing to do so through March 31st to take the tax credits, those tax credits do end March 31st. And then as Ken mentioned, that could change any day. So just know if the legislation passes to extend the FFCRA, then be prepared to issue a new policy or a new communication, and we can certainly help you with that. Finally, also as Ken mentioned, your COVID-19 safe working conditions policies. I'm confident that all of you have those policies at this point, but make sure that they're updated and that you keep them updated. As we've discussed, OSHA doesn't just come to manufacturing plants. They might come and inspect my office here at Warden Smith. They're going to make sure that we're enforcing the COVID-19 protocols. So make sure to update those and just generally look at all of your policies. A lot has changed over the past year. Look at those policies and say, do they reflect current practices? Are they up to date? Are they compliant with the law? So just make sure that you're doing that on at least a yearly basis, if not ongoing. Next, I want to talk about training. We've talked a lot about anti-discrimination, anti-harassment training. Make sure that your managers and supervisors get this training once a year, especially if you have employees who are working remotely. You're not seeing them every day. You're not kind of monitoring in the hallways at the water cooler what they're saying. We need to make sure that our frontline supervisors understand how to handle complaints and how to identify any type of discrimination or harassment in the workplace. They need to have this training once a year. For all other employees, we recommend it at least every 2 years. Second, we highly recommend diversity and inclusion training. Simply put, this training helps increase employee awareness about the differences among us. D&I training also accomplishes important objectives such as interpersonal communication, anti-discrimination, attracting and maintaining your workforce, and reaching business goals. Finally, consider adding training on newer issues that affect the workplace, such as COVID-19 protocols or time management in a remote working environment. If you have non-exempt employees working from home, it's really important that they understand how to clock in, how to clock out, how to take breaks, etc. So I imagine that these are not the types of new hire orientation training that folks got. And so it's important that we're evolving our training as circumstances change. Whether your workforce is in person or you're in your social distancing or your workforce is remote, we're not having the same type of day-to-day interactions and in-person communications with our employees. So now more than ever, it is really important that we stay diligent in employee training. If you need someone outside of your HR department to help, maybe they're tired of hearing from you or you're using the same presentations over and over again, it's something that we're happy to do with and we do every day. I'll give a special plug to Xavier, who you heard from earlier, who has recently provided excellent diversity and inclusion training to some of our clients. So I encourage you to reach out to us if you need any help in that regard. So now I will turn it back over to my friend and colleague, Will Oden, to talk about independent contractors.
Thanks, Emily. Hey, everybody. I hope all of y'all are as impressed with my law partners as I am. Just absolute privilege to work with these fine folks every day. Before I talk about the Department of Labor's final rule that's been announced, really quickly wanted to mention something else that's exciting at Ward & Smith. We have started a management consulting company. It's a fully owned subsidiary of the law firm, and we perform various non-legal business-related services for our clients. The thesis for the business was we had clients that needed things that we were not currently providing for them. And so this is a way for us to do that. And I mentioned it to this group because one of the service arms that we're involved in is to provide HR support to companies that need additional back of house HR help. And in addition to that, just parroting what Emily's already mentioned to you, we perform for a very reasonable flat fee the annual anti-discrimination, anti-harassment training, which we can certainly pair with Xavier's D&I training. And I'll also, he's too humble to mention this, but Xavier was recently named the D&I chair for NC SHRM for the whole state. So he brings a level of that training that I think is unparalleled. So in any event, keep us in mind, please. I'm happy to talk with any of you about that. But now I want to talk to you about independent contractors and employees. So if you've worked with us for a period of time, you know that we've always talked about the importance of properly classifying your workforce, because if you don't, you're exposing yourself to significant liability. Traditionally, and I've practiced since 2004, traditionally, there was the IRS 20-factor test, and then there was the economic realities test. But really, all of these different tests boil down to one word, and that is control. And what you'll see when I talk about this new final rule that the Department of Labor has rolled out, at least in theory, is that control still rules the day. But the economic realities test, just to kind of refresh everybody's recollection, has several factors that we have to keep in mind when we determine whether a worker is an employee or an independent contractor. So in no particular order, we look at the permanency of the relationship. Is the engagement for a limited period of time, or is it open-ended? Obviously, the more open-ended the relationship for the longer period of time, more likely the worker looks like an employee. We look to the extent to which the services are an integral part of the principal's business. So am I, as a worker, coming in to do something that your employees also do? If so, I look more like an employee, of course. The amount of the alleged contractor's investment in facilities and equipment and tools, if the worker is providing their own tools, equipment, and facilities, they look more like an independent contractor. The nature and degree of control exerted by the principal, again, that's really the key factor here. How much control does the organization exert or have the ability to exert upon the worker? The more control, the more likely it looks like an employer-employee relationship. How much of an opportunity for profit and loss does the worker have? The more opportunity for profit or loss, the more likely they look like an independent contractor. And then the degree of independent business organization operations of the worker. And what I mean by that is, whenever I've done a USDOL audit, one of the things they often ask is, does this purported independent contractor have their own website? Does he or she have their own business cards? Do they work so many hours for the business during the week that they don't have the practical ability to offer their services to others in the market? Things like that. And so, in other words, does the individual even operate out in the world other than for this one entity? And that is something that, at least down here in southeastern North Carolina, where I'm located, the Federal Department of Labor is always honed in on. I will tell you, again, before we go through the final rule that's been announced, I will tell you that a written independent contractor agreement is not going to save the day. If it walks like a duck and quacks like a duck, it's a duck. And so we can certainly draft independent contractor agreements for you that tailor the relationship as closely as we can to the requirements. However, you're going to look beyond the agreement to the actual relationship and the facts of each situation to determine the appropriate classification. So with that being said, the new rule, which was announced on January 6th, clarifies the standard for employees versus independent contractors somewhat, I will say. It was currently scheduled to take effect on March 8th. However, there's been a regulatory freezing pending review memo that was issued from the White House that delays the start date until May 7th of this year. So the comment period on the final rule is still technically open until midnight tonight. So if you're really bored, can't sleep, or feeling froggy, you can submit your comments on the final rule until 11:59 tonight. The final rule currently, the way it currently sits, number one, it reaffirms the economics reality test. So those factors we just walked through are still in play. But something that it does differently is it places two of the factors ahead of the others. And so the first factor that it focuses on is the nature and degree of control over the work. So no surprise here, control still rules the day. The second factor that takes the lead in this new final rule is the worker's opportunity for profit and loss. And that's a little different because traditionally we've looked at the factors on a sliding scale. You may be able to satisfy some while you don't satisfy all. But again, the new final rule focuses on the degree of control exercised over the work, and number two, the worker's opportunity for profit and loss. If neither of those two factors are determinative, the final rule provides three other guideposts that serve as, a pathfinder for you. So number one, the amount of skill required for the work. Number two, and we touched on this through the economics reality test, the degree of permanence of the working relationship between the worker and the potential employer. And then third and final, whether the work is part of an integrated unit of production. Now that's a little different than the traditional is what I'm doing for you, very similar to what your employees do. It's a little different, and here's the nuanced difference. They're really looking at, truthfully, whether you are embedded into a particular business unit of the business, as to whether you look more like an employee. So not necessarily performing the same functions as much as you are really part of an embedded, you're embedded as part of a business unit. The final rule also gives 6 examples, which frankly are not super helpful, but they do give 6 examples as to whether someone looks more or less like an employee. Again, those 6 examples focus on control, the permanency of the relationship, the opportunity for profit and loss, and then whether the individual is an integrated part of a business unit. And I would just commend those examples to you for what they're worth. But again, every one of our scenarios, whenever we're asked to classify an employee, or a worker as an employee or an independent contractor, everything is very fact intensive. And so just take a very close look at this stuff because it's important. If you ever have any questions about it, you can reach out to any of us. And now I'm going to turn it over to my friend and law partner, Justin Hill, and save the best for last.
Thank you for that, Will. In the interest of time, I'm going to go ahead and jump straight in. That way we can save as much time as we have for questions. But on January 29th, OSHA recently released updated guidance that was meant to assist employers and workers with implementing a coronavirus prevention program and essentially explaining how to best mitigate the risk of a spread of coronavirus within the workplace. This guidance comes shortly after President Biden passed out an executive order calling for an update and revised guidance to employers on workplace safety. And OSHA's guidance provides a total of 16 elements that are meant to give such guidance and tell employers how to best mitigate the risk. But of those 16, there are 4 that are listed as the key elements. Those are the ones that I will focus on here today, but you'll notice that some of the key elements weave in and out other portions from the remaining 16. Before I actually jump into the elements, I do want to say that OSHA did emphasize that these are recommendations. They are advisory. They're not intended to create legal obligations, but instead to inform employers. But of course, in today's day and age, anything that comes out that is guidance on COVID-19 is something that everybody should probably be paying more attention to than less. So to start off with the key elements, the first one was to conduct hazard assessment. So that means identifying where and how your workers may be exposed to COVID-19 within the workplace. Some of the key things that you are looking for there are places that people can congregate and be in close contact, or places where social distancing just kind of isn't feasible. Whenever conducting these sorts of assessments, employers should always make sure that they are including the workers and representatives of the workers, just for the pure fact that those are the people who are most familiar with their conditions. They're going to know what places should be higher risk, what places should be higher concern, and how to maybe alleviate some of those risks and concerns within the workplace. The second key element is identifying a combination of measures that limit the spread of COVID-19. So some of these measures, obviously, that should be taken are things such as maintaining social distancing whenever possible. And if it's not possible, coming up with ways to create physical barriers to just ensure that, people are safe. Also implementing physical barriers in communal work areas or places where people are going to be gathering, such as where people eat commonly or just common areas in general. You could also look at things like suppressing the spread of the hazard by using face coverings, or, the utilization of PPE, and making sure that people are provided that PPE and provided with the necessary supplies just to maintain good hygiene in general. So some of these supplies that should definitely be emphasized now are making sure that hand sanitizer is available and upfront so people can get access to it as soon as they enter. Making sure that there are no-touch trash cans and the like, and making sure that people have posters that are posted, whether it be in the bathrooms or in the common areas, to show people how to maintain good hygiene and things that will reduce the risk of catching COVID-19 itself. Another piece of that would be performing routine and cleaning, for disinfection often. So you want to make sure that you are cleaning places that are frequently touched surfaces. So workstations, keyboards, telephones, handrails, doorknobs, all of these sorts of areas you should make sure to clean more often than not. But you also want to make sure that you try to give time for those areas to kind of not be a concern for the people cleaning to get sick of COVID-19 as well. The third key element here is to adopt measures to ensure that infected workers are separated. So to start here, workplaces should think about assigning a workplace coordinator itself, someone who basically is the head of keeping up with your coronavirus task force, someone who is making sure that, people can come and talk to them and communicate openly, and someone who is essentially responsible for ensuring safety within your workplace. Going off of that, you should find a way to make sure that your employees feel comfortable talking with that workplace coordinator and making sure that there's open communication amongst the employees. That way, if something does happen, it's actually reported, opposed to people trying to keep it a secret or being concerned about what may come from it. Another part of that is sending workers home if you believe that they, show symptoms, or if they know that they have been infected or possibly exposed to the virus itself, whenever feasible. And at the very least, you should be attempting to isolate those employees from your workers, your customers, and your visitors within the workplace. And again, I want to remind you to remember that this includes those who are just showing symptoms, who may not believe that they've been exposed. You want to be more proactive with this than reactive. If someone has a cough or has a fever, whatever the case may be, you want to make sure that you are isolating this person, keeping them isolated from your other workers to essentially prevent a spread and to protect the other workers themselves. You also want to make sure that you're trying to minimize the negative impact on those who are quarantined and isolated. The essential piece of this, for starters, is to make sure that people, one, report, but two, to make sure that they can continue to, make a living if they do have to quarantine, and to try to alleviate some of the pain of catching the virus, or, trying to make sure that you don't spread the virus. So things that could be utilized here are allowing people to use paid sick leave if it's available, or making sure to implement ways for people to do their job remotely and allowing that teleworking if possible within your workforce. The last of the key elements here is to implement protections from retaliation. So here again, you want to make sure that you keep up the open and clear communication. You want to make sure that people feel safe to come and tell you that they have symptoms or that they have been around someone who possibly has contracted the virus. You also should think about setting up anonymous processes to voice concerns. So remember, you may not discriminate against somebody who is engaging in safety and health activities. So someone who's raising concerns, or someone who's talking about other employees who are not maintaining safe, protocols, or are not following your policies that you may have, you want to make sure that not to discriminate against them, not to, punish them for what they're saying. And you want to make sure to hear them out, especially because, again, you want to prevent the spread of something that could shut down numerous people within your workforce. Next, I want to talk about some of the people returning from, symptoms or exposure to COVID-19. OSHA's guidance says that if it is symptom-based, you want to wait at least 10 days since the person first showed symptoms. You want to wait until they are 24 hours without a fever, and that's without using any fever-reducing medication. And you want to make sure that their other symptoms are improving as well, such as loss of taste or loss of smell. You want to make sure that their senses are at least starting to be regained. If somebody knows that they have been exposed or believes they had been exposed, OSHA also provides guidance saying that they should stay home for 14 days after the last contact with that person. They should basically monitor within those 14 days any symptoms that may arise, and they should try to stay away from others, especially those in large crowds, and definitely want to be safe and maintain distance from those who are at a high risk of catching the virus aside from themselves. While the CDC does provide some guidance saying that 10 days quarantine may be fine for somebody that's not showing symptoms, and that a 7-day return may be fine after a negative test, you want to make sure to kind of lean on the side of caution. So OSHA continues to push the 14 days, and the CDC itself continues to recommend 14 days as well. As a reminder, and as another point that comes from the OSHA guidelines, you want to always remember to try to maintain social distancing. You want to remember to train your employees and make sure that they understand things such as information on the vaccine. Make sure that they understand that people who choose not to take the vaccine are not going to necessarily be distinguished against, but you want to make sure to emphasize the importance of, taking the COVID-19 vaccine. And OSHA actually recommends that employers make it available at no cost if the employees are eligible for it. You also should consider protections for workers who are higher risk for severe illness. So those who are older adults, those with serious underlying conditions, and anybody with a disability, you want to make sure that you are accommodating them appropriately. It's also important that you should make sure that you're sanitizing, disinfecting. You should make sure that you're using PPE and face covering, and you're using the engineering controls like setting up the barriers or improving ventilation, whatever the case may be there. And as a conclusion, I'll leave you all with the thought to keep in mind on March 15th, OSHA is expected to put out more guidance on emergency temporary standards. President Biden's executive order calls for that and set the deadline of March 15th. So I would be on the lookout for more to come on this, virus and what OSHA believes is necessary to be done with temporary standards by that date. And at this time, I'll turn it over to my law partner and friend, Devin Williams, for questions.
Thank you, Justin. Thank you, everybody. So we have a few questions. I'm going to dive right into this. Xavier, I'm going to throw the first one to you because I think it should be one that you can hopefully quickly address for us. Can you explain and give a little bit more detail about what DEI training is and what that entails for an employer?
Absolutely. And thank you for the question, Devin. So DEI, I may have used that term throughout the presentation. That means diversity, equity, and inclusion. And all three of those terms are different. And it's important to know what the distinctions are as it relates to those terms, but what the interplay is as well. There are many benefits to conducting DEI training and having DEI programs. There are several studies that have been done to show that organizations and workplaces that have more diverse environments typically outperform their competitors. And so there's a lot that can go into it as far as the DEI training and programs, understanding, implicit and unconscious bias and how those biases may display themselves in your workplace, in your organizations. And there are many different trainings out there for these type of issues as well. I think, as an employer, it's important for you all to understand, what your mission is and what you all want to do in your organizations and your culture. And that will kind of lead you in trying to identify what training is best for you. There's no one size fits all. It really just depends on the organization and the workplace. But we are happy to help you in that process. We've done DEI training before. Ken Gray and I have, and some other folks on the call as well. So we're happy to engage you in figuring that out if you do have those issues.
Thank you, Xavier. And just to make sure that we say it too, DEI stands for diversity, equity, and inclusion. So I just wanted to follow up on that. Another one, and this is going to be kind of a toss-up, but it goes off of the LGBTQ plus and the Bostick decision. But what are right now employers who are considered a nonprofit Christian organization? Can they have messages about their faith, a statement of their faith and their belief, when that belief is, for example, marriages between a man and a woman, and expectations in that regard? And before I kind of toss this up for discussion, I also wanted to note that there was, back in October, after the Bostick decision, there was a case in the U.S. District Court for Indiana where that court ruled that Title VII's exemption for religious employers did not bar a claim by a female employee alleging employment discrimination on the basis of sexual orientation. That is the first case that we are aware of that has now addressed this issue from Bostick that the Supreme Court kind of left open to be decided at a later date. To what extent does the religious exemption apply under Title VII as to sexual orientation and gender identity? So with that, I would like to get some thoughts from folks. Xavier, I know we just talked with you, but we'd be curious of your thoughts because you discussed the Bostick case. And then anyone else who wants to chime in, please feel free to unmute yourself and pitch in on this question for us.
Yeah, I'll be happy to start, Devin, and thanks for the question. It's a great question, and there's not a fine answer for it, but we'll certainly navigate this area together. And where you want to start is, what kind of organization are you? Are you an institution or organization that is a religious organization, as that as we've seen examples come down from the Supreme Court of what entities would be religious organizations, and so if you're a nonprofit and you're a Christian organization and you identify as a religious organization, then you would, we believe, qualify under some of those religious exemptions. And as far as, that particular question of having included certain things within your application or within the agreement that you have your employees sign, the fact that you don't automatically exclude individuals is okay. I think having that information that you have in that statement, that is fine, just because you're not automatically excluding individuals. I will say that, you want to be cautious in this particular area, and you do want to consult legal counsel before you take any type of action in deciding, whether to hire, terminate someone, or any other adverse employment action if you're basing it off of some type of religious belief or principle, because you want to make sure that you do fall up under a religious exemption. And I'll give you all an example. Recently, we fielded an inquiry about a nonprofit religious institution and they're an educational institution, and whether or not how to handle a call when you've got an individual who wants to be admitted to the institution and they identify as homosexual. And so for that particular institution, if they do not accept federal funds from the federal government, then Title IX does not apply to them. And even within Title IX, there's a religious exemption. And so there are certain things that, won't even apply if you're not accepting federal money from the government. And so those are some things that you want to kind of keep in mind, but it is a difficult area to navigate. And I'll open it up to my colleagues as well to get their thoughts.
Thank you, Xavier. And I'm going to chime in real quick. We understand, we know we are at time. We had this slated to end at noon. So if you have to jump off, feel free to do that. However, we did want to stay on, and we're getting some questions in, and so we wanted to try to answer as many of those as we could. So we're going to take a few more minutes and let you send your questions in and have our attorneys answer those here live. But thank you for joining us. If you do have to drop off, Jen will be sending out a recording of this presentation for you if you were in attendance, and then also with the SHRM and HRCI credit. There will be, Jen will be handling that for us as well, and she will send all of the accreditation information in an email by the end of this week. So thank you for joining us, and if you have time to stick around, I know we're going to get some great insight from my colleagues, so hang tight. So with what Xavier was leading off of, is there anybody else that would like to chime in? I think Xavier knocked it out of the park with that answer, and all right, I'm getting thumbs up. So I'm going to go to another question that we received, and this is certainly a tricky area. And so the question is, can you elaborate on an employer's recourse if an employee's social media post compromise their ability to effectively perform their job duties? Now, we've seen a lot of situations where folks nowadays are going to social media and saying all types of things that are occurring in the social environment that may not actually have an impact on the terms and working conditions of employment, but it could have an impact on their ability to do the job, or it could end up harassing another employee, or ultimately putting the employer in the crosshairs of a PR nightmare. So I'm going to toss this to Grant to tackle for us. And one of the examples that was given is, for example, if a medical professional posted online that transgender people do not deserve the same type of medical care, or that they don't deserve certain types of medical care. And so, Grant, would you mind helping us tackle this issue?
I'd be happy to, Devin. Thank you very much. And thanks for the preface saying it's a tricky area. Because after I volunteered, I thought, gosh, this could be difficult to do briefly, because this question does implicate so many issues, and it's hard for most lawyers to be brief, including me, but I'll give it a whirl. I'm sure you guys hung on every word of my brief presentation about considering conduct outside the workplace, which includes statements these days published on the phone. There is a generation of people who think that unless they publish it, it didn't happen. That's not necessarily true, but it's an excellent question, because employers are free, as I've indicated, to consider the conduct and statements of employees outside the workplace, including social media posts. That is the rule. There are exceptions, as Devin was just alluding to. And as I mentioned during my presentation, statements that deal with working conditions, conversations among employees about terms and conditions of employment are a very tricky area, because employees have the right to discuss those things, including on social media. And sometimes even one employee can engage in what's called protected and concerted activity if it's intended to elicit the involvement of other employees into a discussion about working conditions. But assuming we're not talking about that we're talking about statements that essentially indicate, I'm looking at the question that Devin read, that make comments that essentially are one kind of prejudice or bigotry or of another, or of various kinds, whether it's against transgenders or people who don't look like the person who's published the statement. If the statement indicates some kind of prejudice or bigotry, an employer, a private employer, is free to say, this kind of statement is not consistent with the culture of our organization. We think that this is going to undermine employee morale. It may not pass the newspaper test if it gets out that our employees are making statements of this kind. And although that's not a legal term of art, I would recommend it to you that you're free to apply the newspaper test and ask yourselves, if this gets out in the media that our employees are making statements of this kind, is this going to reflect poorly on us and indicate something about us that is not consistent with our culture and our mission? It's perfectly appropriate for a private employer with those caveats to consider comments like that and to act on them if the employer finds them intolerable. My advice would be that if the employer is going to do that, to touch on something that Emily said about personnel manuals, it's good to have a policy about this kind of thing. It needn't be long, but you want to have something in your personnel manual saying, in effect, that we discourage our employees from making comments that could be construed as unlawful harassment or as offensive in various ways. That's okay to say that. And it's better to have a policy about that, so that when you discuss it with the employee, you can say, look, our policy says on page 18 that we don't tolerate certain kinds of comments that could offend our employees, could offend our customers, our clients. Also, documentation is very important. If you're going to act on statements like this, you want to document why you're doing what you're doing in case your decision is challenged later on. So that's my brief answer, I hope.
Absolutely. That's great, Grant. Thank you. And one piece that I would add to that is try to be as consistent as possible in what you do, because if you allow leniency with one person's comments and then someone else comes in and makes similar comments, that can create a comparator analysis and can actually create a claim where none existed if those two folks are in different protected categories. It shows that you're not consistent, and the only reason, the argument you would hear is the only reason for the inconsistency was because of a protected class. So wonderful advice that Grant shared. The next question we wanted to tackle is, Emily talked about the annual and biannual training in the workplace and how important that is, and the benefits to doing that. Sometimes that might be a good step or actually ordered by the EEOC. But the question is there any state or federal requirement that you actually provide this training? And so, Emily, can you enlighten us a little bit?
Sure. Thanks, Devin. So in North Carolina, no, there is not a requirement. If you have employees in other states, you should certainly look at those the employment laws under those states, particularly New York and California. I know those off the top of my head. There may be other states that do require particularly sexual harassment training. And that's been a recent development over the past year or so. There's also the federal contractors also pay special attention to federal law in that regard, because there was a law, and as we've talked about throughout this presentation, there's a lot of reversing and re-implementing what the Trump administration may have changed. Or so if you are a federal contractor, then be sure to look at those requirements or ask us to look into those for you. And so at a federal level, no, there is no requirement unless perhaps if you're a federal contractor. And then my last comment I'll just make is, although these types of trainings are not necessarily required, we have been really recommending them, especially ever since the Me Too movement, because it's just an area that a lot of folks just really needed training on. And if you do have a complaint filed against you, the EEOC is going to attribute, especially if there's a manager involved, that harassment or discrimination to you, the employer, and they're going to look to you, the employer, and say, did you take reasonable care? How did you take reasonable care to prevent discrimination and harassment from happening in your organization? And one of those is training. And so anything that you can do to try to prevent it. But that's just me on my soapbox. I did not answer your question. I hope I answered your question, and thank you.
Thank you, Emily. Yes, I think you absolutely did. And that additional insight is very helpful. So I've got another one. I'm going to toss it your way, Ken. And this is a combination of where the FFCRA meets vaccines. And so is there any indication that the proposed additional paid leave under the FFCRA that employees who receive a vaccine, would those employees be exempt from receiving paid leave under the FFCRA? Or stated another way, employees who refuse the vaccine, is there any indication that they would still be eligible for extended paid leave under the FFCRA?
Yeah, that's an awesome question, and frankly, Congress could actually do that, exactly what is proposed there, and that would be a way of getting more people potentially to get the vaccine. However, the answer to the question as it stands now is that the vaccine will not affect the extension of the Families First because on the one hand, the vaccine may be somewhere between 90 and 95% effective. There's still a possibility somebody could catch COVID-19 even after they've been vaccinated. And certainly if they qualify for the same list of requirements that Families First had, then they would be covered with a positive COVID-19 test. So that would be one of the triggers that would entitle them to benefits. Also, even if a person is vaccinated, they could still have a family member that they have to take care of, or a child who was out of school as a result of COVID-19. So that a person getting a vaccine is not going to be exempted. And then on the flip side, it would be great to have that requirement of a vaccine to be covered, but they have not done so. And so, now Congress could certainly continue their negotiations and change that, but right now they're not going to exclude people that do not get the vaccine, because there are folks that have legitimate reasons for not getting it, as we discussed earlier on Haley's presentation. A person could have a sincerely held religious belief against vaccinations in general, or they could have a disability or other medical condition that essentially the medical providers are saying you should not get the vaccine due to your condition. So in either of those two scenarios, you'll have a person that legitimately is not getting the vaccine, and to exclude them from the potential benefits would be really unfair.
And Devin, if I could just add to Ken's thoughts there, I agree with everything Ken said. And an additional thought is the existing vaccines have been authorized by the FDA under the emergency use authorization, and a provision of that authorization and approval provides that recipients of a vaccine must be made aware of its risks and have the right to refuse the vaccine. And so I think that authorization, provides that individuals are free to reject the vaccine. And therefore, I don't anticipate that Congress would make receipt of the vaccine a condition of an employee being eligible for leave under the FFCRA, or would use the decision to decline the vaccine to make an employee ineligible for leave under the FFCRA.
Yeah, and I'll add, in fact, there are some major hospital systems in, well, not only North Carolina, but across the country that do mandate the flu vaccine, and most of them are not mandating the COVID vaccine yet. They're waiting for the vaccine to get the full FDA approval, and they're not going to make it mandatory until we get beyond just the emergency use authorization.
Thank you, Ken and Haley. Very helpful information. Well, with that, we have addressed the questions that have come into us. Of course, if you have follow-up questions, you are welcome to reach out to us. We'd be happy to speak with you and assist you on these issues. We greatly appreciate your time today, spending it with us this morning. We hope that you found it valuable. I certainly did. To what Will said earlier, I'm thrilled that I get to work with these folks, and I'm honored that they all enlightened all of us a little bit more on all the issues to expect in employment in 2021. So thank you, and kudos to my team. So happy with y'all. And thank you all for joining us. I will hand it over to Jen to give any last minute information about our HRCI and SHRM credits.
Great. Thank you so much, Devin. And thank you to all of our speakers and to each of you for joining us today. For those in attendance, as Devin mentioned, following the webinar, we will send an email with a list of articles related to the issues discussed today and other helpful information. We also will make a recording of the webinar available. As a reminder, today's program is approved for 2 hours of HRCI, SHRM, and General CLE credit. And additional information on these credits will be provided to you in the same email I just mentioned. Additionally, please save the date for our May 7th Virtual Employment Law Symposium. More information about this event will be sent in the coming weeks. We so appreciate you taking the time to join us today and hope you're able to take some of the information you learned and apply it to your own business. Thank you again, and that concludes our webinar.